So far, we have discussed European citizenship and the benefits it entails for all citizens of the member states. We now conclude these modules with what we hope will never occur, the loss of EU citizenship and due regard for the EU law, together with the proportionality review. Well, we can say that Brexit reignited the debate on the derived nature of the EU citizenship, which is inseparably linked to member states' nationality. Although it is not an autonomous legal status under the current treaties, EU law has increasingly shaped the national jurisdiction, both in the acquisition it has the citizenship by investment schemes monitored by the European Commission and in the loss of nationality, as clarified by the Court of Justice in Rothman and Tibbs. Under Article 9 of the Treaty and 20 of the Treaty on Functioning, any national of a member state is an EU citizen. EU citizenship adds to national citizenship without creating independent criteria. It is the member state that determine who qualifies, thereby influencing access to and withdrawal of EU rights. So EU citizenship is thus derivative, mediated by national laws, consistent with the principle of conferral of competences as Article 5, paragraph 2 of the treaty, and with international law, which reserves to states the power to define their own citizenship. So this approach is also rooted in the 1997 treaty and also in 1997 European Convention on Nationality, reaffirming state competence. And yet, since Micheletti, the Court of Justice has set a limit. National decisions must comply with the EU laws, especially to prevent arbitrary restrictions that would undermine fundamental freedoms. So this balance between national authority and supranational constraints has been further redefined. In Rothman, the court held the deprivation of nationality, though within state competence, must respect EU laws if it affects union citizenship, particularly where statelessness may result. Therefore, while EU citizenship is not yet an autonomous legal institution, the court has progressively strengthened its importance, turning into a benchmark for assessing the legitimacy of national laws that affect European integration and citizens' rights. So compliance with EU law requires national judges to carry out a twofold proportionality assessment. They must examine whether the withdrawal of nationality is proportionate in light of its impact on union citizenship status and whether it conforms to national principles. The Rothman judgment set out guiding factors. The seriousness of the offense, the time elapsed between naturalization and withdrawal, and the possibility of reacquiring original nationality. Given the primary law's importance attached to EU citizenship, national measures depriving individuals of the genuine enjoyment of EU rights may conflict with Article 20 of the Treaty on Functioning. Although it does not create autonomous rules on nationality acquisition, EU case law significantly influences national legal system. So Rothman has fueled the debate on a potentially more autonomous European citizenship, while still leaving a wide discretion to member states. In the specific case, Mr. Rothman's loss of German nationality was deemed proportionate, as he had not taken steps to recover his nationality of origin. The Thebes the Thebes case raises a different issue. A did not Okay, so it is, I think, easier to read. The Tibbs case raises a different issue because it did not concern an individual act of revocation, but rather the ipso jure loss of Deutsch nationality provided for by the Dutch Nationality Act. This legislation establishes the loss of nationality for an adult who, while holding another nationality, resides outside the Netherlands and the EU for 10 consecutive years, with effects automatically extending to minor children. The court was asked to assess whether whether this rule was compatible with Article 20 and 21 of the Treaty on Functioning, in light of the principles established in Rothman. The difference from Rothman is clear. The latter involved an individual measure linked to fraudulent conduct, while Thebes concerned a legislative automatism depriving individuals of EU citizenship without an individual assessment. Precisely for this reason, the court reaffirmed the necessity of a proportionality test, even in the presence of general and abstract rules. So it stressed that the existence of a genuine link with the state remains a decisive criterion, but it cannot operate mechanically without considering the concrete consequences for the individual concerned and their familiars. So, in Thebes, the Court of Justice allowed and followed the reasoning of Rothman. The status of union citizenship conferred by Article 20 of the Treaty on Functioning falls within the scope of EU law, and national competencies in matters of nationality must comply with it. The court examined the Dutch rule providing for the ipso jure loss of nationality for dual nationality adults residing abroad for 10 consecutive years with automatic extension to minor children. This regime was considered compatible with EU law. The residence criterion reflects the absence of a genuine link, a principle also recognized by the 1997 European Convention on Nationality. And moreover, the law itself provides internal safeguards because requesting a Dutch identity or travel document interrupts the 10-year period and preserves nationality. Once the rule was deemed legitimate in the abstract, however, the court required an additional double proportionality test. National authorities and courts must assess case by case the concrete consequences of nationality loss on the individual and, where relevant, their family members. So this may even lead to an extunc reacquisition of nationality. Thus, the case law reveals a dual dimension of review, an abstract one, verifying that the rule is not arbitrary and pursues a public interest, such as safeguarding solidarity and reciprocity between state and citizens, and a concrete one, requiring an assessment of proportionality and individual impact. So, in this way, while recognizing broad discretion of member states, EU law ensures that the loss of national nationality does not disproportionately undermine the status and rights of union citizenship. So, The TIPS judgment um, has some limits, or better, we have to see, to investigate if there are limits of the EU review. Because as regards the loss of nationality for minors, the court upheld the rationale of restoring family unity. Um, Once the Dutch legislation was deemed legitimate in the abstract, the court shifted its focus to the concrete evaluation entrusted to the national authorities' proportionality test. However, the court's reasoning reveals notable absentee EU law itself. And in fact, abstract legitimacy was assessed on the basis of international conventions and the principle of non-arbitrariness, whereas EU law became irrelevant only at the implementation stage, left to national courts. So, in essence, the court seems to consider the rationale for revocation or loss of nationality always legitimate, in deference to member states' exclusive competence. And this raises doubts. Dutch legislation is based on a residence criterion applied only to dual nationals, not to those holding German nationality alone, introducing a questionable distinction in the light of EU law. And the tension becomes clearer when compared with the Micheletti judgment of the 1992, where the court rejected the idea of subordinating the recognition of a member state's nationality to additional criteria such as the effective residence. So, on that occasion, the court held that possession of a member state's nationality is sufficient to establish union citizenship without further conditions. Well, however, in other matters within state competence, such as defining the electorate for European elections, the court accepted the effective residence as legitimate criterion, and the cases were Eman and Sevilla and Spain versus United Kingdom, considering it non-arbitrary. And this reveals a non-uniform line of case law, because on one hand, the court reaffirms the formal principle of nationality possession, and on the other, it accepts residence as a reasonable criterion in certain contexts, reflecting the ongoing tension between state sovereignty and the guarantees arising from union citizenship. So the principle of non-discrimination and limits to state discretion, even in fields not directly linked to nationality, the Court of Justice has identified limits to state autonomy through general principles of EU law, particularly the principle of equal treatment. So the principle of discrimination is a limit to the state discretion, according to the court. And this principle requires that comparable situations are not treated differently and that different situations are not treated alike unless objectively justified. Well, a significant example in the determination of active and passive electoral rights in European Parliament elections, which falls within state competence but subject to EU law. And here, the court relied on the principle of non-discrimination as a legitimacy benchmark, directly reviewing national measures against EU law without limiting the union's role to case-specific proportionality checks by domestic authorities. And this approach was reinforced by the chapter of fundamental rights, as seen in Delvigne case, where the court examined the automatic deprivation of voting rights following a criminal conviction, ultimately finding the national rule compatible with EU law. Well, transposing this reasoning to tips, one could argue that the German legislation introduces unequal treatment. The loss of nationality applies to dual nationals who reside abroad for 10 years, but not to those with the sole German nationality, even in the same circumstances. Such a distinction may conflict with the principle of non-discrimination, which constitutes a binding parameter even for national legislation on nationality. And also, the German legislation on the loss of nationality raises doubt about its compatibility with the principle of non-discrimination because it applies only to dual nationals, whereas those holding solely German nationality cannot lose it. As I said 1 minute ago, in order to avoid statelessness. Moreover, minors lack a safeguard mechanism comparable to that available to adults, such as the request for identity documents, thereby creating a distinction between first class and second class citizens, as noted by Advocate General Mengozzi. While acknowledging that the law pursued a legitimate aim, safeguarding the unity of the family nationality, the Advocate General underlined its disproportionate impact, especially in the light of the best interests of the child, which the law does not mention. And in earlier cases, such as Eman and Sedingner or the Delvigne that I mentioned before, the court had carried out a centralized compatibility review with EU law. In Tibbs, however, it accepted the law rationale but required a stricter proportionality review at national level. So the court required that the assessment take into account not only general circumstances, but also the specific condition of the individual and their family, with particular regard to fundamental rights protected by the Charter, as Article 7 for respect for family life and Article 24 for the best interests of the child. And among the relevant factors are the consequences for freedom of movement and residence, as well as the ability to maintain family or professional ties within the member states. So, thus, while recognizing the broad discretion of member states, the court strengthened review of the concrete consequences of nationality loss decisions, ensuring that they do not result in disproportionate innate limitations on the rights deriving from union citizenship. So the court's case law has made clear that although states retain exclusive competence in nationality matters, the exercise of that power must comply with EU law. And this entails, in addition to proportionality review, also respect for principle of non-discrimination and fundamental rights, including Article 7 and Article 24 of the Charter. As I said, family life and the best interest of the child. Well, against this background, the Italian legislation introduced by Decree Law number 113 of the 2018 that was converted into Law 132 of the 2018 is problematic. It provides for the revocation of nationality for persons who acquired it ex novo through marriage, naturalizations, or birth in Italy to resident foreigners, and it definitively convicted of serious crimes of terrorism or subversion. Um, However, the revocation does not apply to Italian citizens iure sanguinis, thereby creating an unequal treatment between categories of citizens who have committed the same offenses. And so, although justified by the aim of national security, the rule raises concerns. It lacks an internal safeguard to suspend revocation, as in the German law at issue in Thebes, and does not provide for an individualized assessment of consequences for the family and professional life of the person concerned and their relatives. And moreover, the measure is not subject to any compatibility review with the fundamental rights guaranteed by the Union. So this gives rise to the risk of conflict with Article 3 of the Constitution and Article 21 of the Charter of Fundamental Rights of the European Union, which prohibits all forms of discrimination, including that based on nationality. And following the Thebes scheme, if we want to take a scheme from the judgment of the court, it would therefore fall to national courts in absence of centralized review by the Court of Justice to act as guarantors of compliance with EU law, ensuring that the revocation of nationality does not result in disproportionate or discriminatory measures. Well, the complementary relationship between a national and union citizenship continues to raise interpretative doubts, as we can see in the JY case. Mrs. JY, an Estonian national residing in Austria, was granted the promise of Austrian nationality on the condition that she renounce her Estonian citizenship. And after doing so, and thereby becoming stateless, the Austrian authorities revoked the initial decision due to numerous administrative offenses and definitively denying her nationality. So the referring court raised the two questions: whether EU law applied to a person who was already stateless at the time of decision, and if so, whether the principle of proportionality developed in Rothman should nonetheless apply. Advocate General Sputzner highlighted the peculiarity of the case because, unlike Rothman and Tipsa, here the loss of union citizenship did not result directly from the contested revocation, but from the applicant's earlier renunciation of Estonian nationality. And nevertheless, according to the Advocate General, the case falls within the scope of EU law, since union citizenship status, by its very nature and effects, requires compliance with EU law even in the exercise of exclusive national competences. And attention must therefore focus not only on the moment of loss, but also on the concrete and lasting effects that national decisions have on the enjoyment of union rights. And so the Advocate General argued that Mrs. JY's stateless could not be regarded as an autonomous choice. The renunciation of Estonian nationality was a necessary condition for acquiring Austrian nationality, which had been promised by the authorities. So the revocability of that promise exposes individuals to a systemic risk of statelessness and loss of the union citizenship without any responsibility attributable to Estonia. Furthermore, the legitimate expectation created by the guarantee of naturalization should have led the authorities to complete the procedure even in the face of subsequent administrative offenses. And revoking the guarantee of naturalization produces effects equivalent to revoking citizenship already granted, and therefore falls within the scope of EU law in light of Rothman. So Strengthening this conclusion, the Advocate General referred to the case of law of Ruiz Zambrano, which extends protection where there is the risk of losing the essential core of union citizenship rights, and to Loon judgment, which emphasize progressive integration for citizens settled in the host state. So accordingly, um, the applicant situation falls within the scope of EU law, making it necessary to apply the principle of proportionality as well. And well, Advocate General Sputzner referred to the criteria already identified in Rothman, applying them to Mrs. JY's situation. Um, Some of the offenses alleged were already known at the time of the naturalization guarantee and had not prevented its granting. The subsequent one, though serious from an administrative perspective, did not justify a definitive consequence such as the loss of union citizenship, nor was road safety invoked by the state jeopardized, I'm sorry, to such an extent as to warrant a suspension of their driving license. So other elements increased the disproportionality of the revocation. The time elapsed, nearly 2 years, during which JY remained stateless. The impossibility of automatically regaining Estonian nationality, and the restrictions stemming from a humanitarian residence permit in Austria, which affected her family and professional life. All of this created a legal vacuum in which the fundamental rights of the person risked being compromised. So, according to Advocate General, EU law must fill that vacuum to ensure the effectiveness of union citizenship. And the revocation of naturalization in such circumstances is therefore disproportionate to the nature of the offences committed. Hence, the invitation to the Court of Justice to confirm the conclusions already advanced and to provide clear parameters to guide national judges and authorities in assessing proportionality in nationality matters, especially for stateless persons or third country nationals aspiring to become union citizens. Well, mm, the 2016 referendum and the UK's withdrawal agreement from the EU resulted in the loss of union citizenship for British nationals residing in the Union. So several actions, including Schindler, Price, and Silver, contested the Council's decision approving the agreement, but were dismissed by the EU General Court for lack of standing. A French court then referred the preliminary questions, leading to the judgment of the Court of Justice on the 9th of June 2022. This case that I present to you concerned EP, that is a British citizen resident in France since 1984, who had been removed from the municipal electoral register following Brexit. And she complained of having lost her voting rights both in the EU and the UK, where the 15 year rule applied. So the French court asked whether such citizens retained union citizenship status, or alternatively, whether the Council's decision could be invalidated in the light of the principle of proportionality. And the court, endorsing the opinion of Advocate General Collins, answered in the negative. From the moment of withdrawal, British citizens residing in the EU no longer enjoy union citizenship status, nor the associated rights, including voting and standing in municipal elections. So the decision rests on 4 points. The first one, the treaties ceased to apply to the UK. Second, British nationals are no longer nationals of a member state, but of a third country. Third, nationality of a member state is a necessary condition for union citizenship, which the treaties do not extend to third country nationals. And fourth, the withdrawal agreement did not provide any derogation maintaining those rights. So the court thus unequivocally ruled that Brexit means Brexit, as we heard on TV many times, and marking the end of union citizenship status for British nationals, even at the cost of leaving them without any voting rights at both the European and national levels. Well, in its judgment of the 9th of June 2022, the court emphasized that the loss of voting rights for British citizens residing in other EU states was the inevitable consequence of the UK's sovereignty decision to withdraw from the Union adopted by referendum. The situation of EP who could no longer vote either in France or in the United Kingdom due to the 50-year residence abroad rule did not affect the court's reasoning. It considered this an internal electoral choice of the UK, irrelevant under union law. So the court therefore reiterated that any violation of political rights must be asserted against the United Kingdom, not the EU or OSCE member states. Withdrawal from the Union entails renouncing the founding principles enshrined in Article 18, 20 and 21 of the Treaty on Functioning of European Union and of 39 and 40 article of the Charter of Fundamental Rights, and with them the loss of union citizenship status. So the central issue remains the constitutional obstacle, because Articles 9 of the treaty and Article 20 of the Treaty on Functioning tie union citizenship inseparably to possession of the nationality of a member state. Any hypothesis of a special status for British citizens residing in the EU, though raised in academic debate, is not legally feasible without the treaty revision. Neither the court nor the member states have ever intended to create an autonomous union citizenship independent of national citizenship, and this judgment confirms that definitively. So, EP um, lost her right to vote in French municipal elections, and she invoked the case law of Rothman of Tibbs and JY, which, as I said, requires an individualized proportionality review for the loss of union citizenship. The court, however, rejected the analogy because in those just a second, I'm sorry. Invoked, I was saying Rothman and Tibbs and J. Wise, but the court rejected the analogy because in those cases, The loss resulted from member state decisions, whereas here it was the UK's sovereign decision that caused the loss, excluding any duty on French authorities to assess European EP's personal situation. So the central paradox remains. Although she invoked her ties with France, EP had never applied for French nationality, which would have automatically restored her union status. This highlights the current limit. If in Thebes the court upheld the loss of nationality in the absence of a genuine link with the Union, it might have gone further here, recognizing that the presence of such a link could justify retaining EU rights. However, the literal wording of the treaties subordinating union citizenship to possession of member state nationality prevented such an evolution. So, finally, the judgment thus demonstrates that the court's refusal to soften the consequences of Brexit, avoiding any path towards a right to EU citizenship based solely on residence. So it represents a missed opportunity to give innovative weight to the genuine link, but remains consistent with the political legal intention not to make the withdrawal painless for departing member states. Thank you very much.